Write a short note on cause of action. Every suit presupposes the existence of a cause of action against the defendant. If no cause of action exists, the plaint is liable to be rejected. Although the expression cause of action has not been defined in the CPC 1908, it has been explained through judicial decisions. Cause of action may be described as a bundle of essential facts which the plaintiff must prove in order to succeed in the suit. It is the set of the facts that gives the plaintiff the right to seek relief from the court against the defendant. The classic definition of cause of action was given by Lord Brett in Cooke versus Gill, where he observed cause of action means every fact which it would be necessary for the plaintiff to prove. It traversed in order to support his right to the judgment of the court. Thus, cause of action consists of all those material facts which are necessary for the plaintiff to establish his legal right and obtain relief from the court. The importance of cause of action is also reflected in Order 7 Rule 1E of the CPC 1908, which requires that every plaint must contain the particulars of the facts constituting the cause of action and the date when it arose. In Kuldeep Singh versus Ganpat Lal 1996, the Supreme Court observed that the object of requiring the plaintiff to state the cause of action is to enable the court to determine whether the plaintiff discloses a cause of action and whether the suit is within the prescribed period of limitation. If the plaintiff does not disclose a cause of action, it may be rejected under Order 7, Rule 11A of the CPC 1908. Examples of cause of action: suit for possession against a tenant. The plaintiff must state that the period for which the tenant has defaulted in payment of rent. Suit on a promissory note payable on demand. The plaintiff must plead that a demand for payment was made and the defendant failed to pay. Suit for damages for breach of contract. The plaintiff must state that a valid contract existed and that the defendant committed a breach of that contract. Essentials of cause of action. The following are the essential elements of a cause of action: existence of a legal right in favor of the plaintiff, violation or infringement of that right by the defendant, existence of material facts necessary to prove such violation, entitlement of the plaintiff to seek relief from the court. Importance of cause of action. Cause of action is important because it forms the foundation of a civil suit. It determines the maintainability of the suit. It helps the court ascertain jurisdiction. It assists in determining whether the suit is barred by limitation. Absence of cause of action results in rejection of the plaint. Conclusion. Thus, cause of action means the bundle of material facts which gives rise to a legal right in favor of the plaintiff and entitles him to seek relief against the defendant. It is an essential requirement of every civil suit, and the plaintiff must clearly disclose the facts constituting the cause of action. Otherwise, it is liable to be rejected under the provisions of CPC 1908.